This event today is part of our Democracy in Action series, and that series is, as many of you know, one of the ways in which Cal State LA is reaching out to the campus community and beyond as we grapple with difficult issues that have arisen since the November election. So we have now in operation our post-election website, immigrant rights workshops, forums such as this one, all in the service of helping students, faculty, and staff to maintain a dialogue, stay fully informed, and understand that we're a community dedicated to the success and well-being of each other. This is an important time for public universities, and Cal State LA is I think, energized in certain both positive and negative ways around it. We can serve the public good best, I think, by providing opportunities for honest conversation and debate, to delve into the questions that are raised on the national scene and on the local scene about approaches to governance and policy and practice and priority, and to try to elevate public discourse above platitudes, above party lines, and above punches, I guess, right? That's what this Democracy in Action series is about. So forums such as these are not only relevant, they're really crucial, I think, crucial to trying to transform an era of divisiveness into an era of heightened learning. My memory of that concept reaches back to the invasion, Nixon's invasion of Cambodia during the Vietnam War. I was at UCLA, right? And all kinds of things were happening on the UCLA campus. And I was having a meeting with one of my professors, and I was expressing my concern or confusion about what was going on, and classes were being canceled, and there were teach-ins, and people were singing Woody Guthrie songs everywhere. I mean, it was just, it was an interesting time. And what he said to me, his name was Ken Lincoln, he was an English professor at UCLA. What he said to me is, boy, this is a great time to be at a university. It's a great time to be at a university. And I wasn't perceiving it as a great time at all, right? But I was struck by that comment, that this is a great time to be at a university, because the university is a place where we can have these kinds of forums, meetings, discussions, debates, dialogues, where passion and action and reason all work together and help to raise awareness in ways that are, I think, informative and exciting, and help our students understand how important it is to be a student at a university at this point in history. So I really appreciate this series and what it's about. Our guest speaker, Dean Chemerinsky, is I think the perfect scholar to shed light on this topic. I'm very grateful that you're joining us today and helping us think through things. A fund of insight and knowledge and experience, and someone who will lend great value to our ongoing conversation. I want to thank Octavio Villalpando, our Vice Provost for Diversity and Engaged Learning, who has indeed hit the ground running with these kinds of forums and programs and initiatives. He created and organized the Democracy in Action series. I want to thank, of course, Rafe Sonnenschein, the Executive Director of the Pat Brown Institute for Public Affairs at Cal State LA, a real treasure for this university, for helping organize today's important conversation. And we also have the members of the planning group who are helping to organize these very highly successful and really well-attended Forum. Scott Bowman, our Associate VP for Research Scholarship and Creative Activity. Nancy Wada-McKee, the Vice President for Student Life. Martin Adamian, Associate Director for our Honors College, and Alma Ramon from the Office of the Provost. They and a number of others have been engaged and active and really contributing in great ways to the tone and tenor and substance that's been part of these months at Cal State LA. So thank you all for being here, and with that, let me bring up Rafe Sonnenschein. Rafe.
Thank you. Thank you, President Covino, and thank you for your leadership and engagement, service in the public good that has put the university very much out in the community in ways that are really good for all of our work. We're thrilled to have Erwin Chemerinsky here because we want to hear as much from him as possible. I'm not going to say Dean Chemerinsky every time I go over to him, so he's Erwin. So you're Erwin.
Thank you. Thank you.
I think that's as it should be. Erwin is the founding dean and distinguished professor of law and professor of First Amendment law at UC Irvine School of Law, which he founded. He's the founding dean of that law school and almost immediately put it in the top rank of law schools in the United States, where it remains. Previously, he was a professor of law at Duke University and for a very long time at USC. So when many of you heard him speaking on the radio, on television, he was at the USC School of Law from 1983 to 2004. He also taught at DePaul College of Law and UCLA Law School, has his BA from Northwestern and his law degree from Harvard Law School. He's the author of 10 books, including 2 that are have come out. One came out early this year, and the other is coming out later this year. I urge you to read his writing. It's as accessible and thoughtful as anything you will see in the world of public affairs. The newest one is called Free Speech on Campus, kind of an interesting issue. And he's written quite a bit on that topic and really has some great thoughts to share. He's written more than 200 law review articles, writes a weekly column for the Orange County Register. I feel like I hear Erwin's voice in my head when things are going on these days. I mean, I'm not like admitting to an illness, but I'm saying I hear his thoughts because I've read so much of his writing and heard him so many times. I see a lot of you nodding that you feel like you know him if you don't already know him. I've gotten emails from people saying, Erwin doesn't remember me, but I knew him 25 years ago. How many people have sent me those emails? Okay. He was in your debate class, Kevin Baskey, 25 years ago or so he claims. What I find most impressive, because it tells you a lot about Erwin, is that in January 2017, National Jurist magazine again named him the most influential person in legal education in the United States. Until I saw that, I didn't know there was something called legal education. But whatever it is, Erwin is at the top of it. But I have one personal story, which is I worked with Erwin Chemerinsky when he was the chairman of the elected Charter Reform Commission in Los Angeles, and I was the executive director of the other commission, as we used to call each other, the appointed Charter Reform Commission. And Erwin was a tremendous force in that and really played a huge role in the 2 commissions coming together, because one thing you'll learn about Erwin has passionate opinions, but of all the people I know, he's the most open to opinions of people who disagree with him and follows the dictum, I disagree with you passionately, but I will defend to the death your right to say it. I don't know anyone who embodies that more than Erwin. But my favorite thing was when the mayor of the city tried to tell Erwin what to do, and Erwin pointed out that he had tenure. So for my fellow faculty members, may I point out that's one of the best arguments for academic tenure I have ever heard, and the mayor immediately backed down. There's a lot of steel in the backbone of Erwin Chemerinsky. So Erwin, welcome today.
Thank you so much. So much for the really kind introduction. It's such an honor and a pleasure to be with you.
Good. Well, we're going to talk about a bunch of things that are on my mind and I hope are on everybody else's mind, but I want to start by saying usually it's not Erwin time until around the 7th year of a presidency. Presidents have worked with Congress, stuff is passed, stuff is not passed. Around the 6th or 7th year, they get annoyed and they start issuing executive orders. They end up in the courts, and you have all this. We're going in a different direction here. It seems to be Irwin time in the first 90 days. The president's not that interested in legislation. He's issuing a slew of executive orders, and it seems like the real balance of power is now between the president and the courts. What is your take on this unusual circumstance?
President Obama,
We're having some sound problems here. Can we get a little help? Don't all
try
rush
again.
up at once.
I'll try again.
Okay.
President Obama used executive orders during the end of his presidency because he's a Democratic president with a Republican Congress. So, for example, he issued a couple of very important executive orders with regard to the rights of immigrants. One was the Deferred Action for Childhood Arrivals, DACA. The other was Deferred Action for Parents of Americans, DAPA. Interestingly, a federal district court judge in Texas issued a nationwide preliminary injunction that kept DAPA from ever going into effect. That's going to be relevant when we talk about what's going on today. President Trump has a Republican Congress, so one would think that the need for governing by executive orders would be much less. He's impatient. He wants to achieve his agenda as quickly as possible. So he's issued a series of executive orders with regard to immigration. Like what happened with regard to President Obama's executive order, federal judges have issued preliminary injunctions saying they're likely unconstitutional. Just yesterday, a federal judge in San Francisco said an executive order that would have denied federal funding to so-called sanctuary cities was likely unconstitutional. Now, what's interesting is, with regard to the Obama executive order and with regard to the Trump executive order, a federal district court judge issued a nationwide preliminary injunction. Yet, yesterday and this morning, President Trump is reacting as if this is just unheard of, to have one federal judge enjoin an executive order, forgetting that it was just last year that the Republicans were cheering when a federal judge was doing that to an Obama executive order.
He also said a few other things that were kind of striking. He said he was defending the rule of law. If you saw, reading the tweets, he said that the rule of law was what he was defending in the area of immigration. Of course, you have a somewhat different interpretation, I presume, of what the words rule of law would mean.
To me, the core of the rule of law is that no one, not even the president, is above the law. Core to the we're just cutting in and out, but I'm just going to keep talking. Core to the rule of law in this country is that it's the province and duty of the judiciary to say what the law is. And what happened yesterday with regard to the executive order on sanctuary cities, what's happened with regard to the executive orders of the travel ban, is courts performing their function under the rule of law to say this is unconstitutional. And it, to me, is deeply disturbing. And I think this is entirely apolitical to see the kind of attacks on the judiciary just because they're ruling against what he wants. The judiciary ruled against President Obama. The judiciary ruled against President Bush from time to time. But you never saw the vituperative attack on judges that we saw last night and this morning and a few weeks ago.
Now, as we all know, these decisions go from a judge to a court of appeals and then the Supreme Court. And the president sounds quite confident that if it goes to a court of appeals in the Ninth Circuit, which has historically been a more liberal circuit, he can still get to the Supreme Court, and with a fifth justice appointed, ninth justice, how do you see this playing out? I mean, this struggle could go on for his entire presidency, presumably.
In each of the executive orders that's been challenged in courts raises different constitutional issues. The executive order that was enjoined yesterday is one that said that cities that call themselves so-called sanctuaries will lose federal funds. Sanctuary is actually a misnomer here. Sanctuary, think of a church, a synagogue, a mosque, not allowing law enforcement in. That's not what this is about. This is about cities saying they're not going to cooperate with federal immigration officials. They're not going to turn information over to federal immigration officials. They're not going to detain people because the federal government says. And there's such good reasons why cities would want to do this. Victims of crime, witnesses to crime won't come forward if they know that it's going to mean they risk deportation. Won't go to public hospitals if they fear it might lead to their being deported. Parents won't send their children to school if they fear that might lead to deportation. That's why the Los Angeles Police Department has had an order since 1979, promulgated by Daryl Gates, that it's not going to cooperate with federal immigration officials. There's a principle in constitutional law that the federal government can't commandeer, can't coerce state and local governments into action. Congress tried in a law called the Brady Act to say that state and local officials had to do background checks before issuing permits for firearms. And the Supreme Court declared that unconstitutional. The Supreme Court said Congress can't use state and local governments as arms of federal enforcement. And the Supreme Court has said Congress can't put strings on grants to state and local governments that are unduly coercive. And that's what the federal court in San Francisco said yesterday, that the Trump executive order is trying to do exactly that. Also, only Congress can put strings on federal money. The president can't do that on his own. That's also something the judge said yesterday in San Francisco. In the Court of Appeals and in the Supreme Court.
Before we go to the next question, is there any assistance we could get on Irwin's sound? Thank you, Raquel. Okay. Yeah, it's less important to hear what I say.
I can also talk louder.
Okay, that's what we do.
Okay, let's try that.
Okay. I'd like to go to a different direction and then come back, because eventually I want to talk about the new justice of the Supreme Court. I want to talk about something called the Emoluments Clause, which I believe is not a new line of cosmetics from Ivanka Trump, I believe, if that's correct.
Yeah, I think
But
most
many-
people that have emoluments were skin creams.
Yes, most of us thought it was skin cream. What on earth is the Emoluments Clause, and why are you involved in a lawsuit, and where does that lawsuit stand?
There are two provisions in the Constitution that use this strange word emoluments that are relevant to this lawsuit. One provision is in Article 1, Section 9 of the Constitution, and it says that a person who holds a position of trust in the federal government cannot receive a present or an emolument, meaning a. The reason for this is the framers were very worried about foreign influence with regard to the new nation. And they thought one way to keep foreign governments from having too much influence, they couldn't give things of value to people who held positions of importance in the federal government. Donald Trump is violating that literally every day. He is constantly getting benefits from foreign governments. Not long ago, China gave trademarks that he'd been seeking for years. Perhaps not coincidentally, he then changed his China policy. Reflects, I think, exactly the underlying concern of the Emoluments Clause. Or to give another example, there's a hotel in Washington, Trump International Hotel. Donald Trump, in his own name, owns 76% of the interest in that hotel. The other 24% is owned by his children. We now have many instances of foreign governments moving their functions to that hotel when they used to use the Hyatt and the Hilton and the Four Seasons, undoubtedly because it's owned by the President of the United States. He is receiving those benefits. The other clause that uses the word emoluments is in Article 2, Section 1 of the Constitution, and that says that the President may not receive any emolument from the federal government other than the salary paid for the office. In other words, the president can't receive any other benefit from the federal government other than his salary. The reason for this is the worry that a president might try to use the office to line his own pockets. President Trump every day is violating this clause because he's receiving benefits from the federal government. Example, there's an office building in New York that he owns, and it leases an entire floor to the federal government. Who gets the rents from the federal government? Donald Trump. The lease for Trump International Hotel in Washington is clear that the owner of the hotel cannot work for the federal government. Donald Trump is the owner of the hotel. He works for the federal government. He is both the lessor and the lessee with regard to that property. So now I get to your question, why am I involved in the lawsuit? On Monday, June 23rd, an organization in Washington called Citizens for Responsibility and Ethics in Washington filed a lawsuit against Trump for violating these provisions. I am one of several lawyers involved representing Citizens for Responsibility and Ethics in Washington. Why did I get involved? Because what I said a moment ago. To me, what the rule of law is about is that no one, not even the president, is above the law. The president here is violating the Constitution.
Now, originally, that lawsuit had problems of standing, people said, that you couldn't show an injury to you except that the organization had to do a lot of extra work to file the lawsuit. But now some local companies, restaurants, hotels in D.C. are weighing in and joining the suit. Is this suit going to continue or get thrown out for lack of standing?
Oh, I think it's going to continue. I think we had standing even before we filed the amended complaint last week. Standing is simply a requirement that in order to sue in federal court, a person has to be injured. They have to be the right plaintiff. And there was a case in 1982, Havens Realty versus Coleman, that said that a not-for-profit organization has standing to sue to challenge illegal practices if those illegal practices adversely affect how it's spending its money, its time, and the like. That's exactly what Crew alleged here. But we've also now found an association of hotels and restaurants and hotel and restaurant workers to sue as well, and I think that makes standing even clearer. The answer, the opposition from President Trump is due in early May. We'll get to file a response. The judge will probably hold oral arguments in June. So hopefully this summer we'll get some kind of a ruling.
So here's the question. If you win, what happens? What has to happen?
We ask for two things. One is a declaration from the court that the President of the United States is violating the Constitution. Second, we ask for an injunction to order the President of the United States to comply with the Constitution. There's many ways he could do that. He could divest himself of these properties. He could choose no longer to have these properties leased to foreign states and the federal government. Maybe, and it's an interesting question, he could put these in a blind trust where he has no ability to control. Perhaps there's other options. But just because it's difficult doesn't mean that he doesn't have to comply with the Constitution.
So even if Congress does not, say, impeach and convict, which is the one remedy we know about, a court could order the president to comply with a constitutional provision. You've made that clear from the start.
Courts have done that all the time. When President Truman seized the steel mills during the Korean War, the court ordered him to relinquish that and to give the steel mills back to their owners. When Richard Nixon tried to keep the Watergate tapes secret, he invoked executive privilege. The Supreme Court said, no, you have to release the Watergate tapes. He did, and it led to his resignation. We can go on with endless examples going back to the presidency of George Washington. The courts get to determine whether the president's action is constitutional or not.
Let's look at the issue of immigration, which for many of us in our communities here is a tremendous concern. As you know, people signed up for the DACA program and some of the other programs with the expectation that they'd be able to come out from the shadows and participate more openly. Is there any right to not have that once promised taken away, or is that simply subject to what the president decides?
I think there is. So far, one court has given an indication that there is, but it's also, to be honest, a hard legal issue. I'm involved as co-counsel in a suit involving this. It's for a man by the name of Daniel Ramirez Medina. He came to the United States from Mexico at age 7. He received DACA status. He received a work permit. About 2 months ago, a federal immigration official in Seattle, Washington, came upon him, asked his immigration status. His brother said, don't answer the questions. Daniel answered, and he answered honestly. The immigration official said, are you a gang member? Daniel said, no. The immigration official 6 times asked, are you a gang member? Daniel said, no. Daniel has a tattoo on his arm. The immigration official said, that's a gang tattoo. Daniel said, no. It's a tattoo that I got when I was 12 years old. It's my hometown in Mexico. The immigration official didn't believe him, took him into custody. And what he said was correct. It is a tattoo for his hometown, and it had nothing to do with any gang affiliation. And we filed a petition for a writ of habeas corpus, a legal paper to get his release, in federal court in Seattle. And our argument, Rafe, this goes right to your question, is that DACA is a promise from our government to these individuals, and that the government has to keep its promises. A federal court thought at least he has enough chance of prevailing on that they've released him on a small amount of bond, and he's released now. The issue has to be decided. The government's position is that all of the DACA documents, the website with regard to DACA, says that the government has the right to revoke it at any time. And so the government is saying, we can take this away anytime we want. I think our argument is strong. The Supreme Court has said that there's a liberty interest under the Constitution when there's a reasonable expectation to continue the receipt of a benefit. DACA gives to these students a reasonable expectation to continue receipt of a benefit. We've just hired a lawyer at UCI is housed in the law school to represent all of our DACA students on the UCI campus. And I think one of the most important things is that when individuals have encounters with immigration officials, and immigration officials trying to revoke DACA status, for them to have access to a lawyer.
And that goes to my next question, which I'm not sure any of us, including me, have the answer to. Many people think the Constitution's rights apply to citizens only. What right do non-citizens and undocumented residents have under the Constitution?
Generally, non-citizens, including undocumented immigrants, have the same constitutional rights as citizens. I use the word generally, and I'll qualify in a moment. The key Supreme Court case here was one called Plyler versus Doe in 1982. Texas adopted a law that said that children of citizens and children of documented immigrants would get a free public education, but children of undocumented immigrants had to pay for their public education. The Supreme Court declared this unconstitutional. The Supreme Court said the Equal Protection Clause of the 14th Amendment, that no state shall deny any person equal protection of the laws, uses the word person. It doesn't use the word citizen. The due process clauses of the 5th and 14th Amendment, that the federal government, state and local governments, cannot deprive any person of life, liberty, or property without due process of law. The courts have said person means just what it says. It includes documented and undocumented immigrants as well. Now, I said generally, the law does draw distinctions in some regards between citizens and non-citizens. Only citizens can vote. Only citizens can serve on a jury. But generally, non-citizens are entitled to the same constitutional rights in this country as citizens possess.
Does that mean that if you are detained by immigration authorities, you have the right to an attorney?
Yes, you have a right to an attorney, but you do not have the right to a government-financed attorney. Important distinction here. Any individual who's detained as part of immigration proceedings, who faces possible deportation, is entitled to have an attorney be present. In other words, the government can't exclude the attorney. I can show you statistics that the presence of an attorney makes an enormous difference in these proceedings. But unlike criminal cases where the government has to pay for an attorney for those who can't afford them, the government is not constitutionally required to pay for an attorney in immigration proceedings. That's why the County Board of Supervisors in Los Angeles, the Los Angeles City Council, are considering appropriating funds to provide representation for those who face deportation. Santa Ana in Orange County is doing this. I wish the Orange County Board of Supervisors would do this. That seems less likely. But the government is providing funds to pay for the government paid for lawyers.
There's more I want to learn. I've already learned a lot about these things. Refugees and international visitors to the United States. What rights, if any, do they have in our system of law?
Again, in some ways, they have all of the rights of those who are citizens. In other ways, their rights are quite different. They have the same right to freedom of speech that a citizen has. They have the same right if they're being accused of a crime to have all of the procedural protections, like the right to remain silent, the right to a lawyer that a citizen has. But somebody who is here on a visa is here at the pleasure of the government. And just as the government can grant somebody a visa, the government can take away that visa too. There's no right to continue to possess the visa. Lawfully here.
Now let's take a very vulnerable group, airplane passengers. I'm starting to wonder what my rights are as a ticket purchasing passenger on an airplane, having to read the fine print of the contract that says you can basically throw me out the window mid-flight to make room for the CEO of the company. What is going on? Is there something changing in terms of our rights on airplanes that has any legal consequences?
I fly too much. My wife has been trying for years to get me listed on the do not fly list. And I think the one thing I can tell you from that experience is you don't have any rights as a passenger on an airplane. If you read the small print, they have the right to kick you off the plane anytime they want. They have to give you compensation under federal law if they do it. They can bump you. They have to give you compensation. I don't know that United Airlines will ever drag a passenger off the plane again like they did a few weeks ago. That did not turn out well in terms of public relations for United Airlines. But unfortunately, relative to the airlines, we don't have much in the way of rights.
You've commented, and especially in your book on the Supreme Court, about how many little rights we don't notice have eroded, including our agreement when we buy things to be required to go to arbitration instead of having a right to go to court. What is your concern about that, and where does that stand right now?
Let me tell you a story. It arose here in Los Angeles. Involved a man by the name of St. Clair Adams. He worked at a store called Circuit City. I'm not going to ask how many of you remember Circuit City. It would just make me feel old. But it was an electronics store, like Best Buy. And he applied for a job there, and he filled out, like we all do, an employment application. He didn't read the back, truly the very tiny print. And there was a clause there that said, if he had any claims against Circuit City of any kind arising from employment, he could not sue Circuit City. He would have to go to arbitration. He worked there a couple of years, then filed a race discrimination suit against Circuit City. And he filed it in California State Trial Court. Circuit City said, you can't sue us in court. We have this clause, you have to go to arbitration. And sure enough, the Supreme Court ruled 5-4. He couldn't bring his race discrimination claim in any court. He had to go to arbitration. Arbitration clauses are increasingly common. They're often in employment agreements. They're in consumer agreements. I can tell you to a certainty that your cell phone agreement has an arbitration clause. I can tell you to a certainty, without doubt, that any kind of electronic equipment that you use, there's an arbitration clause. Even medical contracts often have arbitration clauses. Not too long ago, I went to see a new eye doctor for the first time, and the receptionist gave me this big stack of papers to fill out. In the middle was a form that I was asked to sign that if any claims against the doctor arising out of the treatment, I could not sue the doctor in court. I'd have to go to arbitration. I asked the receptionist if the doctor would still see me if I didn't sign the form. She said she didn't know. Nobody ever asked her that question before. That doctor saw me. But as you may know, increasingly doctors are saying they won't see patients unless they sign arbitration clauses. Just in the last couple of months, a federal judge in Santa Ana and a prominent lawyer in Orange County told me that doctors that would not see them unless they signed arbitration clauses. Not too long after this happened, I bought a new Dell computer. And as you know, to use a computer or an iPad for the first time, you have to click that, you read the terms and agree to them. For the iPad, the terms are 56 single-spaced pages long. I usually just click agree and use the machine, but I decided to read the terms. And sure enough, there was a paragraph that said that if any dispute with Dell arising out of the computer, I could not sue Dell in court. I'd have to go to arbitration. I wrote Dell a letter saying I did not agree to that clause, and by opening the envelope of my letter, they agreed I could sue them in court if we had a dispute. Dell did not write back. The reason this matters so much is we value our ability to go into court, to have our day in court, to be before a neutral judge. There's all sorts of reasons that arbitration is very biased in favor of business and against consumers and employees. Some of it is you don't get a jury in arbitration that you get in court. Some of it is the arbiters want to continue to get employed as arbiters. They know it's in their interest to rule in favor of the repeat players in the system, the employers, the businesses, and not against them, because then they won't get chosen to be arbiters. And so there's very subtle biases against all of us when we're in arbitration proceedings.
And the courts are not persuaded, at least 5-4, that you did not freely choose that, because otherwise you could not, say, get medical help. That was not a persuasive argument with the 5 members of the Supreme Court.
Right. When my second son turned 26, went to sign him up for health insurance, because up until then he'd been on my plan. And every health insurance option there was had a clause that said if he had any dispute, he would have to go to arbitration. He couldn't sue the company. There was literally no way for him to sign up for health insurance without agreeing to the arbitration clause. It's not a bargain for exchange. If you don't believe me, go into AT&T or Verizon or Sprint and say you want a cell phone agreement without an arbitration clause. You don't get to bargain with them about this.
But that was not persuasive to the court. Did they even address that question?
The Supreme Court said, the California Supreme Court had ruled that arbitration clauses in routine consumer contracts are not enforceable because there's no bargain for exchange. But the United States Supreme Court 5-4 said that was, quote, preempted by federal law, and that arbitration clauses, even when they're dictated, not bargained for, are enforceable.
I have a new lawsuit for you to consider that I just thought of today, because you said that undocumented students who benefited from DACA have an expectation. Suppose you have received health care under the Affordable Care Act, have received treatment, and a replacement law were to remove that. Would you be able to make an argument that you had an expectation by the government for that kind of care?
Unfortunately, no, because when it comes to a government benefit program, like the Affordable Care Act or food stamps or a welfare program, the government can repeal that program anytime it wants.
Okay. Let's talk about the Supreme Court. You wrote a book about the Supreme Court. How many cases have you argued before the Supreme? 5 times. There's a new justice on the Supreme Court, Justice Gorsuch. What's your take on where the court is going to go from here on, especially because Justice Kennedy is rumored to be stepping down? Where do you see this going?
Let me separate that into 2 parts. The first is about Justice Gorsuch. The second is about the longer-term future, so not very long-term court. Neil Gorsuch is going to be a very conservative justice. He's going to be very much in the mold of Antonin Scalia. His approach to the Constitution, as he describes it, is identical to that of Antonin Scalia. I had the chance to read several hundred of Neil Gorsuch's opinions when he was a Federal Court of Appeals judge. I read law review articles he wrote. I read his book on euthanasia. And the only conclusion you can come to is he's going to be very conservative. There's a reason why the National Review and Ted Cruz were celebratory the morning after Donald Trump announced Neil Gorsuch. He is a conservative in the mold of Justice Scalia. And this goes to your question about long-term future, he's 49 years old. If he remains on the Supreme Court until he's 90 years old, which is the age at which Justice John Paul Stevens retired, he will be a justice for the next 41 years. Or as I said to my students, that means he'd be a justice until the year 2058. think about what a large percentage of your life and your career that will be. Now, the second part of your question. Did you know that since 1960, 78 years old is the average age at which a Supreme Court justice has left the bench? As we're together today, there are 3 justices who are 70 years old. Ruth Bader Ginsburg turned 84. Anthony Kennedy will be 81 on July 23rd, and Stephen Breyer will be 70. How likely is it that all 3 of these justices will still be on the court on January 20th, 2021? And that's assuming Donald Trump is a one-term president. If any one of these 3 justices, Ginsburg or Kennedy or Breyer, leaves the court and is replaced by a conservative, it will be the most conservative Supreme Court we've had since the mid-1930s. I believe without doubt that there'd be 5 votes to overrule Roe versus Wade, 5 votes to eliminate all forms of affirmative action, 5 votes to eliminate the exclusionary rule in criminal cases.
Could you explain the exclusionary rule?
Sure. Back in 1914, the Supreme Court said, if police officers engage in illegal behavior, the evidence they obtain as a result is not admissible in court. If police break into somebody's house without a warrant, violation of the Fourth Amendment, and they get evidence that's illegal, that evidence is not admissible. In 1961, the Supreme Court said this applies to state and local police departments as well. The Supreme Court has said this is a key mechanism for deterring police violations of the Fourth Amendment, for ensuring that our police comply with the Constitution. But as recently as 2006, 4 justices said we should eliminate the exclusionary rule. And I think if Donald Trump gets 1 more vote, he'll have 5 to do that.
Let's switch to something else, foreign policy. This morning, 100 senators have been invited over to the, not the Oval Office, but to a room near the White House to meet with military officials to talk about North Korea. If something happens militarily with North Korea, at what point does the Constitution kick in and limit the president's options?
I can tell you what the Constitution says, what I think it intended, and then I can give you the practical answer to your question. Article 1, Section 8 says that Congress has the power to declare war. Article 2 says that the president is the commander-in-chief. I think that means is that before we're in a war, Congress should approve that, unless it's an emergency, like in responding to an attack right on the United States. In practical reality, though, presidents have often engaged in war without congressional approval. We can talk about, was the Gulf of Tonkin resolution sufficient congressional approval for the Vietnam War? We can talk about whether or not there was sufficient congressional approval for the Korean War. We can talk about recent conflict and when there was and wasn't. But the president realistically has enormous power to use American troops, including in battle and conflict, without congressional approval.
That's the practical answer.
Right.
And the last congressional declaration of war was 1941?
Right.
Okay. Let's talk about privacy. What's your feeling about what the direction is of the right to privacy in the United States, including the internet and other things, but wherever you want to go with that, where do we stand with our right to privacy?
The difficulty with the word privacy is it can mean many different things. One is it could mean our freedom from intrusion. When we talk about keeping the police from being able to search us or go into our homes, what we're really talking about is freedom from intrusion. The law of trespass that keeps people going onto your property without your consent is about freedom from intrusion. There, I think the issues are going to come from technology, because technology gives the ability to intrude onto others in a new way. Telephoto lenses can look into your bedroom window. Parabolic mics can listen to your conversations by being pointed at a window. And the law has not sufficiently kept up with these threats. The most obvious example is drones. The law doesn't limit the ability of police to use drones way of gathering evidence and information. You need the law to be able to do that. A second thing that privacy can mean is control over information. When we think about databases and the ability of people to gather information about us, aggregate the information. This came up in the context of when we learned that the service providers for phones, Verizon, AT&T, were turning over huge amounts of metadata to the National Security Agency. The phone numbers we called, that received calls from, how long we talked. And people were concerned. You can learn a lot about somebody by seeing what phone numbers they call. If somebody's calling a suicide prevention line, or if they're calling a cancer advised line, you can learn something that maybe they want to keep private. And the law has not begun to keep up with the enormous growth of information about all of us in informational privacy. You should assume every time you're on the internet, everything you're doing is being monitored. You're leaving so-called cookies. Do you ever, if you use Gmail, do you ever notice how the ads on the Gmail match what you're talking about in your messages? It's because they're monitoring what you're saying. The third thing we mean by privacy is autonomy. Here we mean things like reproductive autonomy, right to purchase and use contraceptives, right to abortion. All of this fits under privacy, but it's a different meaning than intrusion of information. And here, so much depends on the Supreme Court and how soon there's another vacancy and who fills it.
I have a last question for you, Erwin, but before I ask it, we're about to go to Q&A. We've allowed some time for Q&A. I'd like to ask our microphone people to go into position. We have 4 microphone people. Oh, well, let's switch that off. Okay, so let's hear it for our microphone people, folks. Especially when I tell you what their job is going to be, which we will talk about in a minute, but I just wanted to be in position so we can go right to Q&A. Erwin, what's the most positive and optimistic thing going on in the world today, from your perspective, that we can take home with us and march on forward?
Does Clayton Kershaw winning last night count? I've never. Okay, Cubs won 1-0 last night. I've never felt so scared for the country and for the things I believe in as I do right now, and as I've been since November 8th. And yet, I guess where I take optimism is looking at the larger sweep of American history. If you go back to the very first days of the country and compare it to now, there's so much more equality today than there's been before. There's still enormous racism and racial inequality, but there's been tremendous progress. There's still great sexism, but there's much more progress with regard to equality for women. There's certainly homophobia, but there's much more equality for gays and lesbians than there's ever been before, including the right to marry. We have so much more freedom today than we've ever had before. We take freedom of speech almost for granted, but it is so much more accepted today and protected than it ever was before. And so I believe that the pendulum of history very much goes towards more equality and more freedom. Martin Luther King Jr. said that the arc of the moral universe is long and it bends towards justice. And I believe that's right. I think that these next few years are going to be a real period of retrenchment, but I think then the pendulum will swing back very far towards continuing to advance equality and freedom. That's my optimism.
Well, thank you. Thank you very much, Erwin, for that. Our goal with Q&A is to get as many questions in as possible. As you can see, Erwin gives answers that are full and complete, but allow time for plenty more topics to go. I'm going to move it around the room. Our people with the microphones will not hand over the microphone under any circumstances, based on bitter experience for many, many years. They will hold the microphone in front of you. Just remember, a question is usually a declarative statement that moves toward a uplift at the end with a question at the end. That's as distinguished from other forms of addressing our speaker. But we'd like to give Erwin a chance to answer as many as possible, and especially get as many student questions as we possibly can. So if you'd put your hands up, we will, let me take a student question first. Is there a student with a question? Are you a student? Then microphone. Where's our other microphone person?
Dr. Chemerinsky, you say that at one point you feel there will be an extreme swing to the other side. Given the legal structure that is increasingly to the right, could you explain what you mean by that?
It was only 8 years ago that we had a Democratic president and a Democratic Congress. I think that things do go back and forth. I remember when Richard Nixon was elected and being very upset. I remember Ronald Reagan was elected and feeling despair. But Nixon was followed by Carter. Reagan was ultimately followed by Clinton and Obama. And again, what I'm saying is if you do look at the broader sweep of history, I'm sure you see as I do, that there's a lot more equality. There's a lot more liberty today than there used to be. I believe that that's going to be the future of this country as well. I just think this is going to be a period of regression with regard to the things I believe in.
Hi.
My question is regarding.
We're not hearing you.
Hi. Okay.
Speak as loudly as you can because it's not working apparently.
My question is regarding trying to be there.
The United States is the only Western country that has the death penalty. We're one of only 7 countries in the world that use the death penalty. And the others aren't countries we want to be grouped together with from a human rights perspective. It is countries like North Korea, Iran, China. In June of 2015, the Supreme Court heard a challenge to the use of a particular drug in the protocol for lethal injections. It's Midzalem, M-I-D-Z-A-L-O-M. And what this is about is there's a 3-drug protocol used in lethal injections. The first drug is to put the person into unconsciousness, so when the second 2 drugs end the person's life, the individual won't feel pain. Apparently, otherwise, if the person was conscious, the individual would feel excruciating burning, like being on fire from the inside. And the first drug that was used as the initial one in the protocol is no longer available in the United States. The manufacturer doesn't want it used in executions. Another drug was substituted. It's no longer available in the United States. And this drug was then used. In medical terms, it's a sedative. It's not a barbiturate. It's not approved to be used for anesthesia. And there have been a lot of botched executions using this drug. People who were supposed to be in deep unconsciousness who complained of feeling intense pain. Nonetheless, the Supreme Court ruled 5-4 in Glossop versus Gross, Monday, June 29th, 2015, that this drug was constitutional. Justice Alito wrote, joined by Roberts, Scalia, Kennedy, Thomas. Sotomayor and Ginsburg wrote one dissent. Sotomayor and Kagan wrote one dissent. Breyer and Ginsburg wrote another, where Breyer argued the death penalty is unconstitutional. Now to your question. Arkansas's supply of this drug, Midzalem, is set to expire. The drug is only has so much shelf life and is about to expire. So what Arkansas is choosing to do is to execute a large number of people in a short amount of time before the drug shelf life expires. And last week, the Supreme Court 5-4 refused to stay the executions. Justice Gorsuch cast the 5th vote in that direction. And so Arkansas is going to continue over the next few days to execute these individuals. And it all goes back to the Supreme Court decision in June of 2015 saying that it was constitutional to use this drug. And it goes back to this being one of the only countries in the world that still uses the death penalty.
Okay, we have a question over here.
Yes, hello. I just have a quick question. You mentioned that several justices might be retiring or resigning, and that Trump will have, to nominate more conservative justices. Is there any likelihood, let's say, that the Democrats get a tiny majority in the Senate, or is there ways that Democrats can slow down the process or force him to pick slightly more moderate justices in the future?
If you look at the Senate election map for 2018, it is discouraging for the Democrats. The Democrats have many more seats that they have to defend than the Republicans have, and some of the seats the Democrats have to defend are in traditionally red states. The conventional wisdom is that the Democrats have very little chance of taking the Senate in 2018. Maybe things will change sufficiently politically that this forecast isn't true. I mean, after all, a Democrat almost won a congressional seat without a runoff in a Republican district in Georgia. But the conventional wisdom is this is going to be a really hard election for the Democrats. So long as the Republicans control the Senate, the president can have anybody the president wants on the Supreme Court. Unless you imagine 3 Republicans defecting from the Republicans in voting with the Democrats. Not one of them did with regard to Neil Gorsuch. I think with regard to President Trump's cabinet picks, only 2 Republicans voted against any cabinet pick, the 2 who voted against Betsy DeVos. So the answer is there's nothing the Democrats can do to stop President Trump from whoever President Trump wants on the Supreme Court unless 3 Republicans would join them.
Along the same lines about the Arkansas death penalty, there's a theory that law follows public opinion and technology, and the country seems to be turning against the death penalty. Sentences are down, executions are down. Did the window close for the determination that it is in and of itself unconstitutional? That's my first question. The second one is the removal from the plane. At what point does physical force become permissible, assuming they have the right to take you off?
As to the first question, if Hillary Clinton had been elected president, if Hillary Clinton had been appointing individuals to the Supreme Court, I think there would be 5 votes to declare the death penalty to be inherently cruel and unusual punishment. It's highly unlikely, though, that on the current or the immediately foreseeable court, there'll be 5 votes for that. The only hope is maybe Anthony Kennedy, as he's nearing the end of his time on the court, might say the death penalty is inherently unconstitutional. Harry Blackmun, before he retired, came to the conclusion the death penalty is always unconstitutional. John Paul Stevens did. William Brennan did. Thurgood Marshall did. But there's no hint of that from Justice Kennedy so far. In fact, as recently as last Thursday, he was among the 5 to let the execution go on. With regard to force, the question is always reasonableness under the circumstances. It was unreasonable to physically pull this man off the plane the way that was done. Could there be a situation where there's an emergency and the airplane needs to get people off quickly and somebody's not leaving and they've got to use force just to remove the person? Well, then I can imagine it could be reasonable under the circumstances. But the question, whenever you're dealing with force by police, is it reasonable under the circumstances, looked at from that moment of time?
I want to follow up quickly on the first question, because I think the first question was saying, even if there was a change in the House, the Senate, and even the White House over the next 30, 40 years, based on your knowledge of American history, would that be able to overcome a Supreme Court that was solidly locked in a different direction? Or would eventually, I think that's what you were saying, would eventually the court have to bow to public opinion? It would have pretty big consequences for the future if you couldn't envision the court having to respond in some way to a major shift in public opinion and elections.
eventually can take a long time. There was a very conservative Supreme Court into the 1930s, and it had been there for about 50 years. And it regularly declared unconstitutional the major New Deal legislation of Franklin Roosevelt. Ultimately, political pressure, retirements, led to a different Supreme Court. But not until a lot of important progressive laws were declared unconstitutional. Did you know the first time Congress passed a law that limited the use of child labor in manufacturing, the Supreme Court declared that unconstitutional? Well, my point is, eventually will happen, but before that, there can be real harms done to many people.
Hi.
Up so we can
Yeah.
hear you.
Sorry about that. Just a quick question on the recent phenomena that why conservative states are still remaining the poorest states and why they keep on choosing Republican candidates or senators to represent them in government.
Oh, I'll turn to my political science professor colleague here.
Well,
you
you're
have
a
a sense?
political scientist, too.
Uh,
People vote on more than their economic self-interest. They vote on their identity.
They do, and I think so much goes into how a person votes. I think that the vote in favor of Donald Trump, and remember, it was 77,000 votes in Wisconsin, Michigan, and Pennsylvania that determined the outcome of this election. And then you wonder, well, why did it happen? Why was the voter turnout among Democrats significantly lower in places like Milwaukee and Detroit and Pittsburgh than it was in 2012 or 2008? Had it been higher, that made a difference. Why was there such antipathy to Hillary Clinton that I think is part of this? Why were so many of the Trump voters very angry, and he tapped into that anger in a way that perhaps I can't begin to understand? Why did James Comey, 10 days before the election, talk about Hillary Clinton and new emails being discovered and not talk about Russians trying to influence the outcome of the election for Donald Trump? I'm asking all the questions because I think this is part of what explains the 2016 election.
Yeah. You may ask. You've been wanting to ask a question for quite a while.
A number of acts and actions have been taken at both at the state level, and they're starting to talk at the federal level about that regard the term religious freedom and what is religious freedom. What's your opinion of this, and where do you think we're going?
I think one of those basic constitutional principles should be that people should be able to believe whatever they want when it comes to religion. They should be able to practice their religion however they want, so long as they don't inflict injuries on others. So I have the right to believe what I want, the right to discriminate against others, ability to believe my religion, but that doesn't mean that I should be able to not do business with others of different religions. Now, though, is that fundamentalists are trying to say they shouldn't have to comply with civil rights laws because it offends their religious freedom. There's a case pending in the Supreme Court that involves a baker in Colorado that refused to bake a cake for a gay couple and says, that's my religious freedom, I shouldn't have to do that. I don't know of any religion that teaches you're not supposed to bake a cake for a gay couple. And my answer is, even if that's your religious beliefs, you shouldn't be able to discriminate and inflict injury on others on the basis of it. I'm not confident that the Supreme Court's going to agree with me. The Supreme Court held just a few years ago that employers can deny contraceptive coverage to women based on their religious beliefs. And it was 5-4, and I agreed with the dissent. But my idea is we should be very robust in our protection for religious beliefs and for religious free exercise, but not at the point at which it injures somebody else. My right to swing my hand stops when I come close to somebody else's face.
We'll have time for probably 2 more questions. You have one over here?
Yeah, so there's so much law, there's so much changing and conflicting law. How should the novice, the non-lawyer, think about studying law, think about the impact of law in their lives?
Sure. I think the answer is it depends on the degree of detail that you want. I think major newspapers like the New York Times and the LA Times have terrific people covering the law. I think when it comes to the Supreme Court, Adam Liptak at the New York Times, David Savage at the Los Angeles Times have been doing this a long time, and they are great at explaining what the Supreme Court is doing. Maura Dolan, who covers the Federal Court of Appeals and the state courts for the LA Times, is a terrific reporter. If you want more in depth than that on a daily basis, there is a blog called SCOTUS Blog, and it's literally what it sounds, SCOTUS Blog, that does a superb job of covering the United States Supreme Court. Anything you want to know on a day-to-day basis about the Supreme Court, you can get from it there. Then there's blogs that go into even more detail than that. There's a blog called How Appealing that focuses, and it's a great name, for federal courts of appeals. And if you want more than that, there's then wonderful books written about the Supreme Court, about other areas of law. So it's just whatever level of detail you want, wonderful resources that are there.
Hi. I have two unrelated questions.
Can we do them one at a time?
Yes, certainly.
I'm
My first is, what is your view on whether the states who have already ratified the ERA have expired? And my second question is, what do you think are the chances of the National Popular Vote Compact?
I think everyone knows that the Equal Rights Amendment was a proposed amendment that says that rights under law cannot be denied on the basis of sex. And the country came very close to adopting it. There's 3 votes, 3 states short. And the original version of the ERA said it had to be approved within 7 years. And after 7 years, it was still 3 states short. And then they extended it and still didn't get the 3 states. And now there's this effort to try to get 3 states that haven't ratified it, like Nevada and Virginia, to ratify it. And the question is the original language that it had to be ratified within 7 years binding? And the supporters of the ERA say, it's not binding, it's just prefatory. The only thing that's binding is the content of the Equal Rights Amendment. The other side says, but it said when it was put forth by Congress, it had to be approved within 7 years. And there's a federal court decision from Idaho that said the extension for a few more years was unconstitutional. The 27th Amendment was proposed by the very first Congress, but it took almost 200 years before it got to 3/4 of the states. That, I think, could be a precedent for arguing that if we get to 3/4 of the states for the ERA, that would be enough. The National Popular Vote Compact, I think the Electoral College is an abomination. I think in a democracy, the majority of the people should get to choose the president. But the problem is the Electoral College is provided for in the Constitution. And in order to change it, it would take 2/3 vote of both houses of Congress and 3/4 of the states. The small states that benefit from the Electoral College are never going to vote for a constitutional amendment. So there's this idea of, well, what if the states just all promise by compact that they'll vote their electoral votes for whoever wins the popular vote? To this point, only blue states have ratified the compact. It's not going to work that way. There is a solution, though, that could go a long way towards making sure we never again have a president who lost the popular vote. 48 of 50 states, all but Maine and Nebraska, give their electoral votes on a winner-take-all basis. So if you voted for Donald Trump in California, your vote didn't matter in the least. Hillary Clinton got all of California's electoral votes. If you voted for Hillary Clinton in Texas, didn't matter at all. I think that's unconstitutional. That's not in the Constitution. That's by state laws. And if we required some form of proportional allocation of electoral votes in every state, then it would tremendously, statistically, decrease the likelihood of the person who loses the popular vote becoming the president.
We are out of time, and Dean Chemerinsky has to go to another meeting and very quickly, but on behalf of all of us, I'd like to thank you for sharing all of your insights with us, Erwin. It was really fun. And thank you all for coming. It was great to have you here.